what is going on, my brothers and sisters? This is your brother Greg Ward coming from the heart of the Common Law Rights Society. I hope you guys are doing wonderful today. I hope you are staying positive and uplifting one another. I know I've been starting up a bunch of different videos with a bunch of different treatises, but I figure at the very least you guys can go ahead and download it and start looking into yourselves, and I'll give you the introductions and go as far as I can with the time that I have. So this one is another by Brobst, called The Law, the Money, and Your Choice, or the Constitutionally Legal Internal Revenue System and How You Volunteered, by Brobst, July 21st, 2003. Compiled, arranged, and edited by A.F. Beddoe. Alright, let's begin. Ever since the founding of America as a constitutional republic, patriotic citizens of all walks of life have been increasingly concerned about the erosion of our constitutional guarantees and why this erosion has and still is happening. However, the continued pooling of ignorance and of patriot commentators arguing over proper form, while overlooking vital constitutional substantive common law facts, has led to 1,001 procedures and ways being promulgated through the internet and seminars as solutions to the rampant and tyrannical legislative and judicial activism known as public policy. Now, for the first time, from Brobst's lifetime of experience and legal research, here revealed is the actual substantive cause that moved the American citizen away from the literal constitutional common law guarantees into the relative constitutional franchises and privileges established by Congress's spirit and quote-unquote true meaning interpretation of the Constitution. This document addresses what the real substance of the law is, and how it's taught, and how its loss and conversion into many forms has effectively created an unincorporated interstate banking association. This association, which the American people have unknowingly volunteered for, has changed the absolute substantive constitutional rights under the common law into relative privileges and forms. These privileges and forms, called civil rights and procedures of codes and statutes, reflect only the legislature's interpretation as to the true meaning and spirit of the Constitution. Read, be aware, and be wise. From the editor. All right, and once again, just as a side note, my own caveat, this is not legal advice, as always. And without further ado, I hope you guys enjoy the content. The United States of America, in quotes, more typically referred to as the Union of States, lowercase s, began their existence under a charter known as the Articles of Confederation, which came before the Constitution. The Articles of Confederation created states under the common law, but created an ineffective federal government. Under the Articles of Confederation, Congress could not punish any infraction of the law of the nations, The law of nations, also called international law, is the law which determines the rights and regulates the commercial intercourse of nations. The Articles of Confederation did not address or incorporate this quote-unquote law of nations, vital for merchants to settle contract disputes outside the Union of States. Even though the Articles of Confederation were unsatisfactory for forming a strong and proper Union of States, lowercase s, the United States of America, our founding fathers would never have been able to have a constitution without them. Incorporating the law of nations was, therefore, a vital stepping stone to creating an effective constitution. When the Master Charter, the Constitution for the United States, was drawn up, the Articles of Confederation were incorporated into the Constitution by reference under Article 6, Clause 1. And in the footnotes, we have the Union of States began their new and strong union under the Master Charter known as our Constitution. The Constitution incorporates the states into this union through the provisions of its Article 4, Section 3, Clause 1, and therefore by reference the Union of States is also incorporated under the Articles of Confederation. At the same time, the Constitution announces in Article 4, Section 3, Clause 2, the powers of Congress over their, in italics, other property, unincorporated, not incorporated, jurisdiction, It also announces the jurisdiction of the Union of States under Article 4, Section 3, Clause 1. Thus we have the first designation of two kinds of territorial jurisdictions. The first has to do with the Incorporated Union of States, addressed in Article 4, Section 3, Clause 1, also known as the quote-unquote territory, that functions within the strict letter of the Constitution. The second jurisdiction, referred to as in italics, other property, in Article 4, Section 3, Clause 2, is known as a territory, in quotes. It remains unincorporated or not included in the Union of States. I'll finish that little paragraph there, but I want to go back to the footnotes. Therefore, quote-unquote, a territory or other property is subject only to the spirit of the first 10 amendments to the Bill of Rights as interpreted by Congress as they administer that other property outside the strict letter of guarantees of the Constitution and Bill of Rights. The constitutional guarantees are reserved for the Union of States and the people under the Bill of Rights. In other words, there are two jurisdictions available to exist in. Living fully in one means the people have full responsibility for their own actions protected by the Bill of Rights in its absolute and literal form. Here the federal government has no direct contact with the people whatsoever. Living fully within the other means the people have only the rights dictated as Congress's wishes in overseeing their civil rights, which are only relative to or in the spirit of the Bill of Rights. Here is where the federal government has full and direct contact with the people as they see fit for the benefit of public policy regulations known as codes and statutes of this jurisdiction. All right, let me go back to the footnotes. Under the Articles of Confederation, the law of nations was not recognized. But as commerce started to flourish, problems started to appear in trade disputes with foreign nations as to what law was to apply. This revealed a void in the law because although the sovereign state wouldn't recognize the law of nations, the individual could demand his right to contract through the ius gentium, the Roman law. That is why the right to contract is embedded in the Constitution in Article 1, Section 10. It says, see Eliot's debates for footnote 2. Let's see what that was. Right there, that incorporating the law of nations was a stepping stone to creating an effective constitution. Talking about incorporation, it says, as used here, means to put or introduce into a body or mass as an integral part. They're talking about the Articles of Confederation being incorporated into the Constitution, I believe. Let's make sure. Yep, right here, Articles of Confederation were incorporated. And the fourth footnote, the Constitution incorporates the states into this union through the provisions, so that at that point they said means combined into one body. And number 5, unincorporated means powers to administer property not combined into the Union of States. Also, there has been argument regarding which is proper regarding the word state. Should it be small s versus capital S? However, the Supreme Court has ruled many times that it is the substance that controls and not the form. Literally, the word territory, as here used, signifies property, since the language is not territory or property, but territory or other property. Therefore, thus arises an evident difference between the words the territory and a territory of the United States. The former merely designates a particular part or parts of the Earth's surface, the imperial, extensive real estate holdings of the nation. The latter is a governmental subdivision which happened to be called a territory, but which quite as well could have been called a colony, province. A territory under the Constitution and laws of the United States is an incomplete state, quoting Ex parte Morgan, D.C. 20, Federal 298, 305, as well as O'Donoghue versus United States, 289, U.S. 516, and 537, 1933. All right, let us continue on. From the founding of the United States of America and before the passing of House Joint Resolution 192 on June 5, 1933, eliminating gold-backed money, the American money system had a standard, quote-unquote, of value based on the Coinage Act of 1792, authorized and incorporated under the common law principles of the Constitution. This is This is because the basic common law principle on which our Constitution was founded demanded that all debt must be paid as found in Article 1, Section 10. In fact, Article 1, Section 10 is the only place in the Constitution where demand for payment is made. Therefore, before June 5, 1933, public policy demanded payment of debts, and all payments were based on the public money national standard, hereinafter called the Standard or Standard. This means that public policy then was also based on the Standard. That Standard contained the literal letter of the law of the Constitution. You see, for someone to be paid means that a promise has been fulfilled, a contract completed. Before modern supermarkets and department stores, the primary way of obtaining a needed item or material was by barter. If one needed a sack of salt, they went to the person who had the salt and would trade something they possessed of equal value for the salt. Because gold and silver have from the beginning of time been very highly prized as a medium of exchange, our founding fathers knew it was the only medium that could maintain and assure the payments of debt in all trade or commerce under the Constitution. Thus, our Constitution states under Article 1, Section 10, no state shall make anything but gold and silver coin a tender in payment of debts. So, if one was to use gold or silver coin as a medium of exchange, then one could use the gold or silver coin to trade for the salt in the example above. All right, let's see what footnotes we missed. There's nothing in HJR 192 that defines value or the effects of what is to take place regarding the suspension of the gold standard. They don't tell you that it is going to affect contracts, bring in third parties, and that there is a residual of the debt left over. Nor is there any place in the Constitution, especially under Article 1, that gives the federal government, under its general lawmaking powers, the right to enact HJR 192 and to create something that has no standard of value. However, Congress does have the power under unincorporated power of local, territory, law, as expressed in Article 4, Section 2, Clause 2, to enact legislative laws for a class of persons subject to the 14th Amendment, especially Section 1, Clause 1 and 2. And then it goes on to say, the Constitution does not protect the sovereignty of states for the benefit of states or state governments as abstract political entities, or even for the benefit of public officials governing the states. To the contrary, the Constitution divides authority between the federal and state governments for the protection of individuals. See New York versus U.S. 112 S. Court. I don't know what that means. I apologize. 2408. All right, let's continue on. All right. This barter or trade was based on a verbal meeting of the minds and agreement between the person that had the salt for sale and the person who had gold or silver or some other item of value to trade or exchange for salt. When the exchange of equal value for value took place, the agreement or contract was paid and fulfilled complete. That is, the contract was made and paid at the same moment between the two parties. There was no debt after the barter or the sale or contract was completed between two parties. There was nothing left owing by either party after the transaction. Substance had been bartered for equal substance, value for value. There was no third-party intervener as there is today. This is because there was no way for the federal government to have jurisdiction over a primary state citizen unless that citizen was to enter into a bilateral contract with the federal government. And even then, there was literal 10th Amendment protection for the citizen in the bilateral contract, because public policy dictated by the substance of the common law was still demanding the payment of debt. Then, the government power could come under Article 1 in rem and not the public policy of diversity, operating quasi in rem that we see today under HJR 192, 12 U.S.C. Section 95A, 15 U.S.C. Chapter 41, Section 1602, and Article 4, Section 3, Clause 2. At the founding of the Constitution, all disputes between persons in commerce usually had to do with unfulfilled or unpaid agreements or contracts. Therefore, the law of contracts in the Constitution was founded on the common law necessity of all contracts being fulfilled or paid when made. Without a medium of exchange containing a predictable and measured substance, no agreement or contract could be properly or completely paid. If unpaid, the law of contracts was unfulfilled, incomplete, or lacking, because there is no contract without payment. The substance, gold or silver coin, of the common law dictated that all contracts must be paid in order to exist, was not exchanged, therefore a contract did not exist. Contracts are considered to exist only when they are paid. And that goes down to section or number 14, or where he made the contract, but it is deemed to be contracted, not where it was entered into, but where payment is due. Digest 44, 7 and 21 was relied upon in court, for instance, in the 1792 Scottish case of Armour versus Campbell. Anyway, all right. It was because of these vital principles that contracts can only be paid via a medium of exchange that contains the standard substance or law substance that our founding fathers wrote Article 1, Section 10 to guarantee a consistent, unchanging weight and fineness to our gold and silver coin, money, as well as the law that follows it. Have you ever heard the expression, the law of the land? This expression was first used in the Magna Carta and meant the common law of England in opposition to the civil or Roman law. And according to Black's Law Dictionary, the meaning is that every citizen shall hold his life, liberty, property, and immunities under the protection of general rules which govern society. In America, the basis of all law that governs our society is our national constitution and its common law principles. At least that was what our founding fathers intended. But what has changed since then? Well, the substance of the law of the land has been removed. Yes, on June 5, 1933, Congress enacted House Joint Resolution 192 that removed the hard mineral substance known as gold, also referred to as portable land, from giving consistent, predictable, and exact value to our money. Silver was demonetized as payment of debt in 1862 when Congress changed the silver standard from $1 in silver to the silver dollar. Since then, silver is considered a commodity and was finally withdrawn from circulation in 1964. Silver certificates were withdrawn in 1972. The hard, precious metal substance known as gold and silver used in coins comes from the earth. It is literally portable or movable substance from or of the land, the law. Land and law go hand in hand because in times past only those that owned the land had access to the portable law substance, gold and silver, that was found in the land. Likewise, those that owned or controlled the land made, produced, or brought forth the law standard of gold and silver. Despite HJR 192, Congress cannot override the state government's incorporated powers under Article 1, Section 10 of the Constitution. Despite current public policy, Congress cannot override an American's right to maintain a private policy under the common law principles as they are expressed in the first 10 amendments of the Bill of Rights of the Constitution. However, because the gold is the standard substance of the law and the law follows the standard substance of money, when Congress, acting under public policy, suspended the standard gold substance in payment of debt, a shift away from the common law transpired by what is called operation of law. The shift, you guys have heard me say that before, operation of law. The shift occurred because everyone was given a quasi-corporate privilege under HJR 192 of not paying their debts, even though it is demanded under the common law of each state in the Union according to Article 1, Section 10 of the Constitution. A corporate privilege or franchise has two aspects to it. First, there is perpetual succession, which can exist independent and beyond the demise of any current directors. And second, there is limited liability for the payment of debt. This means that similar to corporations, HJR 192 offered individual Americans an artificial connection to and relationship with the federal government outside the literal common law of the Constitution for the purposes of Social Security. However, unlike corporations, this artificial connection and relationship was not under any corporate charter, federal or state, as addressed specifically under Article 1, Section 8, Clauses 1 and 3, being one of the government's general powers. Rather, this relationship is controlled under Article 4, Section 3, Clause 2, because there is no physical federal or state charter issued to regulate this relationship. This connection or confederacy developed under HJR 192 is an affiliation better known as an association. According to Black's Law Dictionary, It's an unincorporated society, a body of persons united and acting together without a charter, but upon the methods and forms used by incorporated bodies for the prosecution of some common purpose, but will not include the state. And the common enterprise of this unincorporated society is to offer all Americans a so-called privilege, in the form of what is better known as a quasi-contract, to participate in commerce without payment of debts for Social Security purposes. Moreover, this unincorporated society is outside the literal common law principle that demands the payment of debts as stated in Article 1, Section 10, but it is allowed, upheld, and protected by Article 1, Section 10 that upholds obligations of contracts. Yes, the people's right to participate in this federated, unincorporated society by operation of law is contractually protected by the Constitution. That is to say, each person has the right to domicile themselves in a state of the Union under Article 4, Section 3, Clause 1, thus to contract under Article 1, Section 10, despite the fact that you cannot pay your debts. In other words, Congress cannot compel you to participate in a federal interstate unincorporated banking association under Article 4, Section 3, Clause 2, and HJR 192 for the non-payment of debts. The choice of law is up to each person still. Corporations are artificial creations of the state or federal government under physical charter or franchise, issued via state or federal civil law for commercial regulation under Article 1, Section 8, Clause 1 and 3. They are not under the literal common law because of the charter or the franchise. Any legal action against a corporation is legally called an in rem action, because it is against the thing or property, also called res, of the corporation under charter. The courts have automatic subject matter jurisdiction because the physical charter is the subject matter. On the other hand, under HJR 192, there is no physical charter issued by the government out of a state or federal secretaries of state's offices that defines the federated association's duties, responsibilities, its officers, etc. This results in a federated association that is a quasi-in rem unincorporated debtors' society. The law treats this association as an outlaw entity to the letter of the common law for the payment of debt. The courts then proceed to uphold contract law under diversity, to establish the association's guidelines by invoking their equity powers based on the spirit of the Constitution. They will form a charitable trust to commercially regulate the association, because it is presumed that because it is presumed that is what the group intended, as there is no charter of incorporation. Under the letter of the constitutional law, there is no commercial regulation. But HJR 192, along with its 15 USC, brought in a third party for commercial regulation for Social Security public policy. Remember, equity compels performance. The law views unincorporated associations as a danger to the substance of the common law because of their debt credit system. This is because there is no counterbalance to the demands the association puts on the substance of the earth, thus the reason for all the federal and state regulatory agencies. Some footnotes. I skipped a couple up top, so there's probably some good ones, but this one right here says, as the court stated in the Propeller Genesee Chief, the law contains no regulation of commerce. It merely confers a new jurisdiction on the district courts, and this is its only object and purpose. It is evident that Congress, in passing the law, did not intend to exercise their power to regulate commerce. The statutes do no more than grant jurisdiction over a particular class of cases. So that's something to keep in mind. We're talking about in rem and quasi-in rem, a particular class of cases. Anyway, I'm going to stop there, you guys. Well, should I? Let me go on one more. I think you guys would appreciate one more. All right. In other words, there is a presumption, by implication in the civil law, that a charter, a metaphysical, abstract, unreal type, exists because persons are availing themselves, volunteering, of the privileges pertaining to HJR 192. Therefore, these persons come under a quasi-in rem jurisdiction of the civil law in order to regulate, control, including compel, those that are outside the literal common law principles. Yes, as long as the individual remains silent, it is presumed that they have volunteered for the non-payment of debt privilege under HJR 192, 12 U.S.C. Section 95A, and 15 U.S.C. Chapter 41, Section 1602, C, D, and E. As such, they are considered as a debtor-creditor in a Social Security association, unchartered, unincorporated commune, whereby each person insures everybody else in the association by agreeing never to demand payment for debt. Under this volunteer arrangement, these persons become primarily a U.S. citizen, secondarily a state citizen, subject to Clause 1 of the 14th Amendment, while the literal 10th Amendment rights are forfeited. Moreover, because of this unincorporated Social Security debtor association has participants from each state, it forms an unincorporated federation, better known as federalism, of state associations under interstate commerce as addressed in Article 4, Section 3, Clause 2, and reinforced by Erie Railroads versus Tompkins. This is how the federal government and state governments under federalism can compel you to perform to the civil Roman law known as statutes, state or federal. Here's the answer to why the IRS continues to say that the income tax are voluntary, and yet Americans don't know how they volunteered. HJR 192 literally placed before the American citizen a choice of law between operating under the literal common law principles of the Constitution or the private Roman civil law functioning under federal Social Security spirit and true meaning of the Constitution. That is to say, there are two jurisdictions available for the American people to choose from. The first jurisdiction exists within the Union of States expressed under Article 4, Section 3, Clause 1, where the literal letter of the Constitution and its first 10 amendments function to protect Americans from the public policy of federalism. The second jurisdiction is set up through Americans voluntarily accepting only the spirit, which is referred to as the true meaning, quote-unquote, as interpreted by Congress, of the Constitution via Social Security privileges and immunities under the implied or quasi-contract in federalism for the non-payment of debt administered by Congress as public policy of the, in italics, other property jurisdiction of Article 4, Section 3, Clause 2. Those who have volunteered for the privileges and immunities of the federal social debt security of the unincorporated interstate banking associations for the non-payment of debt have no access to protection of the strict letter of the Constitution under the first 10 amendments of the Bill of Rights, especially the 10th Amendment. See the attached diagram to assist you in understanding. Before HJR 192 existed, the federal government could not have any implied contact with Americans. They could only have an actual contact through a two-party bilateral contract. Americans were presumed to be under Article 4, Section 3, Clause 1 as primary state citizens. After HJR 192, the voluntary, unincorporated Federal Social Debt Security Association, known as federalism, was formed under Article 4, Section 3, Clause 2, supported by 15 U.S.C. Chapter 41, Section 1602, C, D, and E, and 12 U.S.C. Section 95A, becoming the new quote-unquote public policy, that is, implied contracts. See also quasi-contract as footnote 19. Under federalism, have become business as usual, i.e. public policy. By you volunteering to go along with HJR 192, there is a presumption you are primarily a U.S. citizen under Section 1, Clause 1 and 2 of the 14th Amendment with privileges or immunities. Going along with HJR 192 means you do not have the literal letter of the Constitution with the Bill of Rights working on your behalf and in your behalf. Because you have volunteered into the Social Debt Security Unincorporated Association of Federalism, the courts, under conflict of law, diversity principles, look at your life, liberty, and property as relative, not actual. Your life, liberty, and property are converted to privileges or immunities and civil rights. As a debtor, there is no absolute literal property ownership, only a privilege of possession. Sounds like a benefit, or again a privilege. Instead of the literal constitutional law protecting you, you are only afforded the spirit of the Constitution as interpreted by the courts, judicial activism, and statutes. In other words, the court places the statute in front of the Constitution and interprets the statute and never interprets the Constitution. The statute was made by Congress with the Constitution in mind. Thus the statute is the spirit and true meaning of the Constitution as interpreted by Congress as it administers its quote-unquote, or in italics, other property under Article 4, Section 3, Clause 2. Yes, under HJR 192, the Americans have volunteered to give up their land because they have forfeited the substance of the land for the convenience of a federal commercial social debt security system via the jurisdiction of a territorial or incomplete state of other property or governmental subdivision promoting an unincorporated interstate banking association to defer payment of debt. This is what the milestone decision of Erie versus Railroad versus Tompkins is all about. Erie states the law that applies is the law of the states. Sorry. This law of the state means the law of a territorial state or governmental subdivision operating under Article 4, Section 3, Clause 2. Therefore, this volunteer debit or debt credit system has made the literal constitutional common law of the state into a feudal common law, private Roman civil law, under federalism by operating under Article 4, Section 3, Clause 2. All right, so I'm going to stop there. We are at just finished page 10. I'll let you guys check this out. I'll put the link in the description below. I hope you guys enjoy it. Keep reading it, and I'll try to come back and finish it. But yeah, this was The Law, Your Money, and Your Choice by Lee Brobst, and he offers solutions towards the end. So click on the link and keep reading. All right, have a beautiful day. We'll talk to you soon. One love.